This is the final podcast on certainty of terms. In this podcast, we talk about agreements to negotiate and anticipation of formalization. The general rule with agreements to negotiate is that agreements to negotiate do not constitute contracts. The reason is that they are too uncertain to constitute any binding force. First, it is impossible to determine the content of a duty to negotiate. Is it too uncertain? It is too uncertain to support a contract. How far does an obligation to negotiate go? Second, there is no basis upon which to determine damages for breach of such a duty, and even if negotiations had been undertaken, one cannot presume that they would have succeeded. And third, if a presumption of success is warranted, one still can't determine what the terms of the agreement reached would have been, so there is no basis upon which to assess damages if a party breaches. In spite of this rule, there are occasional and limited exceptions. Empress Towers involved a series of leases. One expired and a new lease was made. The new lease contained a renewal clause. It gave the tenant bank the right to renew, which was exercisable by 3 months' written notice. The rental for the renewal period was said to be the market rate prevailing at the commencement of that renewal term, as mutually agreed between the landlord and tenant. Before the lease expired, the bank wanted to renew. It proposed a rental rate of $5,400 a month, up from $30.97 per month, the rate it was paying under the lease that was about to expire. It also said it was willing to negotiate. It indicated the figure was calculated by independent appraisers. Empress, the landlord, responded on the day of the first term was due to expire. It said it would allow the bank to remain on a month-to-month basis if $15,000 was paid as a lump sum, and thereafter the rate of $5,400 would be acceptable. And it said the tenancy would be terminated on a 90-day written notice. Empress brought an action for possession against the bank, which simply means it wanted the bank out. The issue here is, can a duty to negotiate in good faith be imposed? And the ratio is the duty of good faith negotiation can be imposed depending on the circumstances. Remember, courts will always try to find a contract. They will try to give proper legal effect to any clause the parties understood as having legal effects. There are 3 categories of options. The first is, if the rent is to be agreed, the clause cannot be enforced. Where the rent is to be established by a stated formula, but no machinery is provided for applying the formula, the courts will supply the machinery. Where the formula is set out, but defective machinery is provided for applying the formula to produce the rate, the machinery will be used to cure defects in the formula. If the parties had said that the tenant wished to renew, it could only do so at market rate prevailing at the commencement of the rental term, then that would have been easy, because the market rate would have been determined, and if necessary, the court would have made that determination. The problem in this case is the additional line saying that the prevailing market rate as mutually agreed between the landlord and the tenant. Also, that failure to agree would give rise to a right of termination. Now, the effect of all of this is, A, to ensure the landlord cannot be compelled to enter into a renewal at a rent the landlord hasn't accepted as the market rate, and it is implied that the landlord will negotiate in good faith with the tenant with the objective of reaching an agreement. This is in accordance with business efficacy principles. The renewal clause was clearly intended to have legal effect. This prevents it from being struck down as uncertain. Now, the obligation to negotiate may be based on Empress's bad faith here. The defendant entered into a prior contract on the basis of the value of the option to renew the lease, and the plaintiff's behavior appeared to be vindictive. Now, two factors are important in this decision. First, there is an existing relation between the parties, and the existing relation made it easier to recognize that the bank had an expectation that the lessor would negotiate the renewal. The bank never claimed that it already had an enforceable lease, but rather that the lessor had not behaved in good faith by ignoring its request to negotiate its renewal. The bank was never guaranteed a lease. The obligation of the lessor to negotiate in good faith doesn't mean the lessor won't insist on a term that might be reasonable but unacceptable to the bank. In the next case, Manpar, as we're going through it, try to think of the difference between Manpar and Empress. In Manpar held a permit under a contract with the Crown to remove and sell sand and gravel on a First Nations reserve. The initial term was for 5 years, and the option to renew was for a further 5 years, subject to the satisfactory performance and renegotiation of the rate. Both parties expected the term to last over 10 years. Because Manpar would require that time to do the reclamation work, it was obliged to perform on the area. Manpar gave notice of its intention to renew the permit, but the Crown wouldn't do it before the expiration of the original permit, and ultimately Manpar took the position that the Crown was repudiating its obligation to renew. The issue here was the defendant required to negotiate for renewal, and the court found there is no obligation to negotiate in good faith. Now, they found an obligation to negotiate in good faith in Empress Towers. How do you distinguish it? You distinguish it on 2 bases. First, the length of the lease. Here, the parties only anticipated that the business arrangement might last for 10 years. In Empress, it was a continuing lease. Second, they looked at the Crown's position. The Crown had a fiduciary duty. A fiduciary duty is where a person who is required to act for the benefit of another person on all matters within the scope of their relationship. This person owes to the other the duties of good faith, trust, confidence, and candor. A very high standard of care must be exercised if one person is managing another person's property or money. Now, the language chosen in this agreement reflects the Crown's desire to afford it considerable latitude in deciding whether or not to agree to the extension of the permit. The Crown wanted to reserve broad ambit for itself to enter or refuse to enter into any new arrangement. So most importantly here, this isn't just an ordinary commercial transaction, it is a fiduciary relationship, and the Crown had to keep the band's interests in mind at all times. So how do we think of Empress Towers then? How do we slot it in? Well, Empress is basically an authority for the only exception to the rule that there can be no contract to bargain in good faith. Namely, where an already concluded contract requires the parties to negotiate a specific contract outside of the contract. There is a big difference between 2 parties who agree as a term of an existing contract to negotiate in good faith to arrive at a secondary contract, and 2 parties who initially had no existing contractual relationship agreeing to negotiate in good faith to conclude a contract. Now, ask yourselves, should we draw this distinction? Why not? And this is a question that you will be thinking about as we go through the material, because the concept of good faith will come up again and again, especially in light of the next case we're going to briefly talk about, and then we'll talk about later in the year. The case that I'm talking about is the 2010 Supreme Court decision of Bazin, where the court found that there is an organizing principle of good faith that parties generally must perform their contractual duties honestly and reasonably, and not capriciously or arbitrarily. The Supreme Court did not mention contract negotiation, as in it did not say that the parties have an obligation to negotiate in good faith, but it did specifically say that parties perform their contractual duties in good faith, which implies that contract negotiation is in fact not included. Prior to Bazin, the Supreme Court had acknowledged the existence of a duty of good faith in defined aspects of contractual performance. So, for example, in the Wallace case, there was an implied contractual duty of good faith in the manner in which an employee is dismissed. In Witten, the court found that the insurer is subject to a contractual duty to act in good faith in the assessment and payment of policyholder claims. The decision of Bazin means there can be a standard of good faith conduct in a commercial context and an ability to decide whether it's been violated. And of course, the other question to ponder as we go through the material is, what exactly does a duty of good faith mean? What is good faith? And what does it require the parties to do? That is not answered in the Bazin decision, and it is an ongoing question. In the Wellington case, the Wellington City Council appeals from a judgment holding it liable to pay the second respondent, Alray, damages of $580,000 for breach of contract. The contract which the judge found the council to have breached was what he called a process contract, which obliged the council's officers to negotiate in good faith with Alray for the sale of the council's interest as lessor in a certain premises. Alray was the lessee, and the judge found that the council, through its officers, was in breach of that contract by failing to conduct the negotiations in good faith. In this case, the court mentioned Empress Towers, saying an agreement to bargain in good faith does not give rise to an enforceable contract. The only exception is where an already concluded contract requires the parties to negotiate a specific contract outside that contract. For example, the rent on a renewal of a lease. So is the process contract enforceable? Well, the essence of the common law theory of contract is consensus. It follows that for there to be an enforceable contract, the parties must have reached consensus on all essential terms, or at least upon objective means of sufficient certainty by which those terms may be determined. Those objective means may be expressly agreed, or they may be implicit in what was expressly agreed. That's at paragraph 30. Now, taking the concept of consensus to enforce good faith obligations, the court emphasized that the enforceability of good faith obligations will depend on their terms and particularly on the specificity of those terms. A bare agreement to negotiate in good faith with no more definition than that of what the obligations of the parties were is illusory, because there is no sufficiently certain objective criterion by means of which the court can decide whether either party is in breach of the good faith obligation. However, agreements about specific procedures to be followed, as in process agreements, are enforceable. And they found that the process contract between the council and Alray was unenforceable. It was a contract to negotiate in good faith with no more definition than that of what the obligations of the parties were. They agreed with the English approach, which seems to have been accepted, at least implicitly, by this court. The full agreement must be specifically precise for the court to be able to spell out what the parties must do in exercising their reasonable endeavors. And the majority had then said that where the objective of the best endeavors and the steps needing to be taken to attain that objective are able to be prescribed by the court, a best or reasonable endeavors obligation will be enforceable. There is, of course, the rider to that approach that process contracts can be enforceable if sufficiently definitive of the parties' obligations, and the court said that the council's appeal must succeed, as there was no enforceable process contract, there can have been no actionable breach of it, and hence no basis for an award of damages. The final topic under certainty is the anticipation of formalization. Where does this situation arise? This is where the parties reach an agreement, orally or in writing, and they will contemplate that full details of their agreement will be embodied in a further written document. This is where you'll see the words subject to contract. The agreement reached will outline the matters settled and the matters yet to be agreed upon, referred to as, quote, a letter of intent or a memorandum of agreement or a memorandum of understanding. The issues that will arise are whether the parties intended to be bound by the terms of the agreement, and if they did, whether those terms are sufficiently certain to give rise to a contract. Now, practically, these agreements are important in negotiations of transactions. They motivate parties to finalize the details of a possibly complex agreement by providing assurances that such investments of time and money will yield results. They allow parties to move toward the conclusion of their agreements. Now, the general rule here is that language of this sort often indicates that the parties did not intend to be bound to the agreement until a formal document was executed, but the courts will see it as a matter of construction. In the Colonel's Popcorn case, a representative of the plaintiff company approached the defendant with a view to acquiring franchise rights for a retail store. The defendant supplied an information package which included a draft or standard form of a franchise agreement of about 50 pages containing many detailed provisions. A meeting took place between representatives of the two companies, at which agreement was reached on 4 points of variation from the standard form, and at the end of which the parties shook hands and the defendant's representative said, "You've got a deal." Subsequently, the defendant submitted a form of franchise agreement for execution, but it did not comply with the terms of the oral agreement, and the plaintiff's solicitor then asserted that the plaintiff was willing to sign an agreement in the form to be agreed with another franchisee at a different location. The defendant withdrew from the transaction, and the plaintiff brought an action for damages for breach of contract, and at trial the action succeeded. The issue here was the oral contract a complete and legally enforceable contract, or was it subject to formalization, which means dependent upon the written contract being settled, approved, and executed. The ratio was parties may bind themselves to execute at a future date, which is a contract to make a contract, a formal written agreement containing specific terms and conditions when they agree to all the essential provisions that will be incorporated into the formal document with the intention that their agreement shall thereupon become binding. But where the original contract is incomplete because essential provisions haven't been settled or agreed, or because the contract is too general or uncertain to be valid, and is dependent on the making of a formal contract, or the parties' legal obligations have been deferred until a formal contract is approved and executed, then the preliminary agreement cannot constitute an enforceable contract. Here, the court found that no final agreement had been reached. The parties clearly contemplated signing a formal written contract. They had reached agreement on certain issues on April 18th, but they did not discuss or even contemplate some of the other terms. There were therefore still important terms to be agreed upon, so there was no meeting of the minds between the parties.